An arbitral tribunal may be asked to make an award that is simply declaratory of the rights of the parties. Modern arbitration legislation often makes express provision for the granting of declaratory relief. This may happen as a matter of the law governing the arbitration proceedings or as a result of an agreement of the parties. Even when there is no such provision, however, there is no reason in principle why an arbitral tribunal should not grant such a relief. Indeed, declaratory relief has become a common remedy in international arbitration, with requests for contractual damages usually coupled with a request for a declaration that there has been a breach of contract. Declaratory award may be useful for further negotiations or adaptation of contracts in long-term or relational contracts.
Comparing litigation versus arbitration, the default, if there is nothing in the contract, is that litigation will be the method of dispute resolution. So you can either have in your contract a submission to jurisdiction clause, whether exclusive or non-exclusive. If exclusive, the parties are agreeing which court will resolve the disputes. If non-exclusive, they're saying, at the very least, this court can hear the disputes, but other courts may also. Arbitration is a process by which the parties agree that the disputes will be removed from the courts and heard by an independent tribunal. So no court will have jurisdiction to determine the merits of any disputes that are within the clause if an arbitration clause exists.
So let's talk about procedural orders in general first. During the course of the arbitral proceedings, the tribunal will make many procedural decisions or arrangements, such as scheduling meetings, scheduling hearings, conference calls, establishing procedural timetable for submissions, ruling on requests, and addressing hearing logistics. Many of these decisions are made in the form of a procedural order, usually a relatively brief written communication setting out the tribunal's decision on a particular procedural issue. Where only a single, relatively limited issue is concerned, a procedural order may be a single page, or sometimes the tribunal's decision may be communicated by letter or email.